present on is a study that our firm had developed and passed over to the Calgary Counselling Centre called Kids in Mind. But in order to get an understanding of what we were trying to achieve with Kids in Mind, I want to tell you a little bit about our firm and our firm's philosophy. One of the things that we wanted to achieve when I opened my firm was we wanted to make sure that clients were really listened to and that we took a very client-centered approach, but that meant finding out what is it that our family law clients need. They don't like telling their story over and over and over again to a variety of different professionals. We also know that there's a certain readiness factor that comes into play in order for clients to proceed through their legal matters in an effective way. When a client comes in, if they're highly emotional, that's the kind of stuff that drives us to court because they're dealing with a visceral reaction rather than really thinking things through and making sound legal decisions. They have a great deal of financial stressors. When you're taking one household's finances and dividing it into two, certainly there's an adjustment there, and compiling that with legal fees and any other fees that may be associated with their legal matter can be very stressful on the family. We also know that there's different social stressors, primarily things such as domestic conflict, we have addiction issues, we have immigration issues, and mental health issues that can impact the file. So when we were listening to our clients, we know that they prefer a multidisciplinary approach, and this is all anecdotal. We know that we can do that through community partnerships, and that's a fairly easy fix. And we know that they want the legal footprint minimized on their matter. In fact, one of the things that I do when I'm training my associates is I tell them from day one, the first day that you have the file, you should be working yourself out of a job. The last thing that we know that clients want is predictability. That's a harder thing to achieve because we've got usually 4 personalities, if not more, dealing with the file at any given time. Addressing some of the issues that the clients had led us to develop what we call client support coordination. We have a full-time person on staff, and their job is primarily 3 things. Number 1, they vet the clients, first to see if there's any precursor issues that we need to deal with, such as mental health issues or other issues that may impact the file. And then we set those clients up with the appropriate lawyer within the firm who can address those issues. The other thing that the client support coordinator does is they act as an internal ombudsman. And what I mean by that is, number 1, clients know at the initial consultation that they can call the client support coordinator with any concerns that they may have about their lawyer or their file. It's an anonymous call, so they don't have to worry about anybody spitting in their soup. And they can vent to the client support coordinator, who will then address their issues for them. The client support coordinator also has the authority to take a file and transfer it to another lawyer within the firm if the client isn't comfortable. The other thing that the client support coordinator does is they call back the clients on a regular rotation to make sure that the client's needs are being met, because we know not everybody likes to call in and complain, even when there's a problem that arises, and then those are the ones that end up reporting us to the Law Society when really it was something that could have been resolved. The other role for the client support coordinator is they act as a liaison or community outreach worker. So they form partnerships with different community programs to make sure that our clients have resources available to them. So instead of just telling a client, oh, I think you need a counselor, here's a pamphlet, we know that the client support coordinator has an agreement signed, a confidentiality agreement signed, and a release that allows the client support coordinator to retell the client's story if we're referring to a particular agency, so that the client doesn't have to continue to repeat their story. We also have partnerships with the Calgary Counselling Centre and a variety of other agencies that deliver services that we trust to our clients and can assist them throughout their legal matter. We also developed what's called the Step Forward program. This was to try to address those financial issues, such as when a client is going through their legal matter. It takes about a year, we found, from the feedback we were getting from clients, for them to really adjust to a new budget from having one household and now having 2 sets of bills and only that same income stream. And what we did was we reached out to reputable community businesses and we said, listen, why don't you offer discounts to our clients that will help them kind of adjust through the year and in exchange, we will do some free advertising for you. We don't get kickbacks from them. We just help those businesses that help our clients. This has been very well received, and all of the businesses that we co-brand with are businesses that clients are looking for when they're going through their life transition, such as moving companies, daycares, psychologists on there that do bilateral assessments at a discount for our clients. Then we decided to create some other resources for our clients to assist them. One is called Your Family Matters. It's a radio show that can be accessed on demand online. The thought behind this particular show was clients come in often and they'll ask us about things like parent coordination and other things, and we said, well, let's put together a radio show so that we can refer them to that, and then they don't have to pay our legal hourly rate for us to explain it, and we're probably not explaining it in the way that it needs to be explained in any event. Then we also developed our client lending library. Every time I attend a conference, I end up coming home with overweight luggage because I see a new book or 10 new books that I think would benefit the clients, and we make sure that we have the lending library available. I want to talk about in Alberta how custody matters are dealt with. There is essentially a lack of triage. Nobody's really looking at the front end when clients are coming through our doors as to what else is going on for them that may impact their file. Also, custody matters aren't dealt with in morning chambers. So morning chambers is the first application that we bring to court. We're there, and essentially what happens in morning chambers is we get very, very interim orders sometimes. But with respect to custody, we're told no custody and access issues will be dealt with in morning chambers. It has to go to what's called a domestic special, which can take months, sometimes years to get into, depending on the complexity of the matter. So by the time we actually get into court on a custody matter, things have changed, the family's needs have changed, the children's needs have changed. Oftentimes things have escalated and they become a bigger mountain, which also drives things toward litigation. Family lawyers in Alberta are in court more often than anybody else. However, with the Supreme Court of Canada decision of Jordan that came out a couple of years ago, we are now seeing that criminal matters get dealt with before family matters, because the Supreme Court of Canada said that if we cannot deal with a criminal matter start to finish within 2 years, even the most heinous criminals can walk. Also, when we actually get before a judge, sometimes we're asked to go have our clients do bilateral assessments or some other kind of assessments. These can take months to be completed, which again just delays the actual resolution to the matter even further. And then there's the impact of the legal costs when we're going to trial. And then after you get an order, then we have to deal with a lack of compliance, where some clients just will not follow the order. The number one question I always hear from my clients, and every single client asks me this question, is how much is it going to cost and how long is it going to take? Well, I usually tell them, if you're reasonable and I'm reasonable, that's half the battle, but we don't know what we've got coming at us from the other side. You know your spouse better than I do. What are they like to deal with? Can you have a conversation with them? And, what is their lawyer like? Because sometimes the lawyers are the ones that can drive the file sideways. I know because I've been that lawyer. Not on purpose. I was invited by the Minister of Foreign Affairs in Iceland to go over and sit with the judiciary and meet with them and see what it is that they do. Not because I'm a groovy lawyer, simply because I'm Icelandic. But I took the initiative to go in any event. When I was there, I was speaking with the judiciary and I said, how do you deal with custody and access issues? And they said to me, oh, very simply, we make a decision on the bench, but we have a psychologist on the bench with us acting as a consultant to give us feedback about decisions that we could be making that would benefit the family. And I thought, this is so simple and it just makes a lot of sense. So I decided I'm going to take this idea and make me sound like I'm the coolest kid on the block and develop a study out of it. The objectives that I was trying to achieve with this study is, first of all, I wanted to have either a psychologist or a social worker act as a consultant and have somebody running the MED-ARB portion. And I wanted to set it up so that we could find a way to answer how do families do when we actually take a full-on multidisciplinary approach with their custody and access matters. And also, is stress reduced when families have a predictable timeline in an ADR process? We developed 2 groups that we're studying. One group is an open-ended, multidisciplinary MEDARB, where the parties themselves decide how long each MEDARB session is going to take, but it's full-on multidisciplinary. The second group, however, we've got limited timeline. So we've got a set period of time with which the mediator and the parties and the consultant have to make an interim decision. We then send the families out for any assessments or therapy that they may require on an interim basis, and then we have them come back and do a longer session to put together a more comprehensive parenting plan that will take them on a go forward with a follow-up after 6 months. My suspicion, which has been confirmed by some anecdotal evidence so far, is that when clients are told this is how long you have to get through this, or a decision's going to be made for you, they're more motivated to get right to the heart of the issue rather than sit around and point the fingers at one another. We can then say to clients, okay, if you go into the Kids in Mind program, which will follow the study, it's going to take you this long to get through it because it's timed, and it's going to cost you this much because we're going to be able to quantify it. So that at least with child and custody issues, if all goes well with the study, we're then going to be able to answer that question. How long is it going to take and how much is it going to cost with respect to child custody matters? The other thing is if we end up quantifying it and it comes to some larger number than what a family can particularly afford, they're probably going to think about other ways of trying to resolve their issues, or maybe not dig their heels in as far, because everybody has a connection to cost. So the study design, when we were looking at doing it, we wanted to make sure that it aligned with the Alberta Wellness Initiative and the research coming out of there. They've done a lot of work on the impact of toxic stress on children. So that was the key. How do we achieve a program that actually looks at getting people to be more conciliatory rather than fighting? We have 3 long-term goals with respect to the study. One is to create an effective program where we can answer the question, how much is it going to cost and how long is it going to take? We also have a long-term goal to redesign the legal aid system and bring a proposal to legal aid where we say that when there's an effective proven effective program, ADR program in the community, we would like to see families go to that prior to getting a legal aid certificate to go to court. We also have the long-term goal of having the market dictate whether or not community-based programs for families will be the norm. In a perfect world, in my utopia of family practice, families wouldn't even go to court. Now, I became a lawyer because I love being in court. Cross-examination makes me tingly, but I know how awful it is for my families and how polarized they become when they go through a litigation process. So I have a duty to my client first, and I want to make sure that that family is going to be okay and that they're going to resolve their issues in the healthiest way. So ideally, I would like to see all family matters one day end up in community conferencing and having family law issues dealt with in the communities in which people reside rather than downtown in a courthouse. When we have family tribunals or ADR processes, we can relax the rules of evidence and really do what's in the best interest of children. Some of the challenges that we've had with the study is, first of all, we don't have any funding for this study. So running a study that is solely based on volunteer efforts and no funding is really challenging. Also getting support from the profession. It's always difficult to get support from colleagues when you're trying something new. Furthermore, one of the things that we found we had to do with the study, we used to house it within our firm, but a lot of other lawyers were thinking, oh, this is just a marketing gig for the firm, or they're looking to poach clients. I can assure you, family lawyers in Calgary have more clients than God. We don't need any more clients, and we're not doing this for any back-ended reason. To address that, Judge Flatters and I actually set up a Kids in Mind website separate from the firm, and we moved it into a completely different location, and we got volunteers to answer the phones and whatnot, so that there wasn't this perception of bias or perception of it being influenced by our firm at all. And then the other challenge we faced was getting 2 disciplines to work together on the same page. Psychologists and lawyers were trained very differently, so it took a lot of time and collaboration to get a model that worked for everybody. Would we like funding? Sure. And in fact, we have a second model proposed if we were to get funding, where we would have regular provisional psychologists that would be supervised by a fellow by the name of Dr. Chang, who some of you may be familiar with, and he would be governing over the provisional psychologist so that we wouldn't have to rely on the roster of volunteers. Where we're at now with the study, we need 60 families to go through the process in order for our results to be statistically significant. Because of the delays in getting things going and not having the funding to move things as quickly as we had liked, we have only had 4 families through so far. And this is just in the study. We did run this program at a reduced rate prior to the study, and so we have had some anecdotal information from those families. But for the families that have engaged in the study itself, we've only had 4, and they're not through 100% yet. But we are getting more families engaged in the process, and but at this stage we have no quantitative data to gauge how things are working. We were hoping that by this time we would have at least had some interim measures, but that hasn't yet happened. And that's my presentation. Thank you.